Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part of our news session. We will begin with the exciting news about Oliver Campbell, as the Court of Appeal has finally handed down the judgment on his case. Next, we will examine recent development regarding joint enterprise. We will also review key events that have occurred or are upcoming this month, and we will wrap up with an update on Lucy Letby. Be sure to stay with us until the end to catch the latest on the criminal justice system and wrongful convictions. Beginning with Oliver Campbell, the good news is that his appeal has been allowed, his conviction overturned, and a retrial declined. However, despite Mr. Campbell's clear joy, brilliantly captured in this still, the appeal was allowed somehow reluctantly and on a very limited ground. The Court of Appeal's decision did not come as a surprise, though. In fact, we were able to predict the outcome in our June news session, which you can find linked in the description below. You can find background information of Mr. Campbell's case in our video False Confessions, Oliver Campbell 32 years later, which is also linked in the description below. Essentially, and in short, Mr. Campbell, who had impaired mental capacity due to an accident suffered when he was a baby, was convicted of robbery and murder in 1991. His co-defendant, Eric Samuels, was convicted of robbery. The prosecution case against Mr. Campbell essentially relied on three strands of evidence. His confession made during police interview, but which he later retracted, along with a witness identification and a cap found at the scene which belonged to Mr. Campbell. The defense argued that the confession was the result of intense questioning without any accommodation for his vulnerability and susceptibility. It was extracted from him after multiple oppressive interviews, most of which occurred without a solicitor or an appropriate adult present, rendering it inadmissible. Regarding the cap, Mr. Campbell stated that this had been stolen from him before the robbery, and as far as the identification was concerned, this was unreliable, as the police suggested Mr. Campbell positions of the identification parade to the identifying witness, who also gave the suspect's height estimate significantly lower from Mr. Campbell's actual height. His first appeal in 1994 was rejected. Mr. Campbell spent 11 years in prison before being released on license. An application was submitted to the CCRC first in 1999, but this application was rejected a few years later. A second application was submitted in 2020, and this finally led to a referral last year to the Court of Appeal. Essentially, the defense application to the CCRC relied, amongst others, on further statement from Professor Judgement, the original psychologist used at trial, who admitted that at the time he assessed Mr. Campbell, he did not properly understand the full nature of his vulnerabilities, and also on the statement from a BBC reporter who had covertly recorded Samuels, Mr. Campbell's co-defendant, saying in October 2001 that Mr. Campbell was not with him on the night of the incident. The same admissions were made by Mr. Samuels to the police originally in 1991, but as he did not take the stand at trial, this statement was not admissible. The CCRC referral to the Court of Appeal relied substantially on one ground, namely the fresh expert evidence from two psychologists, Dr. Beck and Professor Judgement, which establishes that there is a real possibility that the Court of Appeal may now find, on the basis of the modern psychological approach that flows from the experts' evidence, that Mr. Campbell's admission were unreliable. The CCRC also mentioned that a change in the law now meant that Mr. Campbell's co-defendant's admission that he was not at the crime scene could be relied upon. However, the CCRC said that these were not capable of constituting a separate ground of appeal, but were mentioned simply as capable of being supportive of the fresh evidence provided by the experts. The Court of Appeal dismissed the co-defendant's admission, stating that though it was accepted that the evidence of Samuel's exoneration of Mr. Campbell could now be ruled admissible, it is by no means certain that any of the hearsay evidence of Samuel's statement will be admitted. The court added, but even if it was, it could, in our view, carry very little weight, and it cannot afford or even contribute to a ground of appeal. No reason was given for this conclusion. So, as we predicted, the appeal succeeded on one ground only, namely the fresh expert evidence from Dr. Beck and Professor Judgement in relation to the mental status of Mr. Campbell and the admissibility of his initial confession. The court said, paragraph 133, we accept that the fresh expert evidence, in particular that of Dr. Beck, adds material information about the risk of a false confession, which was not and could not be known at the time. It follows that the conduct of the trial would have been materially different if that information had been known at the time. The court also said to that must be added the change in practice as to the treatment of vulnerable suspects and defendants and the potential availability of an intermediary to assist the appellant at trial. On that narrow but very important basis, we have concluded that the convictions are unsafe. Aside these main points, there are a few other points that we wanted to highlight. The first is that although Mr. Campbell's notice of appeal included 17 grounds, only 5, which were those related to the CCRC referral, were automatically allowed. The remaining grounds required the permission from the Court of Appeal in accordance with Section 14, subsections 4A and 4B of the Criminal Appeal Act 1995. Interestingly, before the Criminal Justice Act 2003, any CCRC referral to the Court of Appeal allowed the appellant to advance all grounds without needing leave, regardless of whether they were supported by the CCRC or not. However, in 2002, during the Court of Appeal's ruling on Jeremy Bamber's case, which we discussed in our video Why Cases Aren't Making the Cut, Part 1, Jeremy Bamber, the court made general comments, including one in paragraph 522 of that judgment that led to these provisions. The paragraph states, in this regard, there is one further observation that we feel compelled to make. This is that it seems to us that there is a significant deficiency in the statutory framework that provides for a reference by the CCRC to this court of a matter. We have no difficulty at all with the concept that there should be a machinery to review potential miscarriages of justice where no other avenue of appeal remains. Once a matter has been referred to this court, it is clearly right that the court should fully consider those matters that have caused the case to be referred by the CCRC. However, it does seem remarkable to us that the appellant, following a referral to the court, is then entitled to raise any matter he wishes as a ground of appeal, without either it having been deemed worthy of consideration by the CCRC or the leave of the court having first been obtained. We have no doubt that some of the matters that occupied the time of the court raised on behalf of the appellant were of such little merit that the court would, if it had the power, have refused leave to argue them. It is remarkable that the court adopts this stance, particularly in circumstantial cases, which many of these are. In such cases, the Court of Appeal frequently highlights how the prosecution's case relies on multiple strands of evidence, each varying in weight and significance, which collectively support a conviction. However, the same logic is not applied when considering grounds for overturning a conviction. In our view, it is only reasonable to present every possible argument indicating an unsafe conviction, as individual grounds may not carry much weight on their own, but when considered together, they can paint a different picture of the case. Particularly given the fact that the defense has the arduous task to prove that something did not happen. As we all know, logically, it is almost impossible to prove a negative, such as showing that something did not happen or that you were not involved. That is indeed the reason why our criminal justice system places the burden of proof on the prosecution. However, we have already highlighted in previous occasions the frequent double standard evident in the Court of Appeal's decision. Needless to say that those grounds unrelated to the CCRC referral were belittled and dismissed by the court as being without merit. Some were dismissed on the basis that they were without any evidential foundation, such as police officers' deliberate oppressive conduct during interview. Others were dismissed as these were points which either were or could have been made to the jury at the trial and as such not permissible, such as, for example, the fact that Mr. Campbell is left-handed, making it difficult for him to draw a gun from a holster under his left arm, or the height difference between Mr. Campbell and the robber's estimated height from the sole identifying witness. However, it is important to note that there is no specific law which prohibits raising points on appeal that were raised or could have been raised at trial. The principle that prevents this has been developed entirely through case law, not by statute. And it has been developed taking into account several principles such as the jury supremacy, legal certainty, and finality of decisions. However, we contend that this perspective does not align with the legislation and the court should move away from it. Section 2 of the Criminal Appeal Act 1968 simply states that the Court of Appeal must allow an appeal if the conviction is deemed unsafe. Moreover, the statute is clear that the court must act in the primary interest of justice. Section 23 of the Act, in fact, provides that for the purpose of an appeal or an application for leave to appeal under this part of this Act, the Court of Appeal may, if they think it necessary or expedient in the interest of justice, order the production of materials, summon witnesses, or admit evidence not presented at trial in order to determine the case. We must conclude that this case law lacks legal basis. In cases where a miscarriage of justice is suspected and a conviction appears unsafe, the interest of justice must take precedence over concerns of jury supremacy or finality. The central question for the court should be whether, when considering all factors presented, the conviction is unsafe. This should include any arguments that raise doubts about the conviction, regardless of whether they were presented at trial or the reason for not doing so. While we recognize the importance of jury supremacy, it should not influence the appeal process at this stage. Wouldn't it be more logical for the court to consider any issue related to jury supremacy during the second stage when determining whether to order a retrial? In other words, the court should first assess whether the conviction based on all available evidence is unsafe, and if so, the court should allow the appeal and quash the conviction. Once and only once this decision is taken, the court should then consider whether its ruling may undermine the principle of jury supremacy. And if it does, the court may order a retrial so that a new jury can review the case in light of the court's findings. However, if the court can justify that its decision does not interfere with jury supremacy, a retrial shall not be necessary. What are your thoughts on this approach? Let me know in the comments below. Overall, despite the seriousness of the concerns raised, the court appeared hesitant to critically examine potential flaws in the process, reflecting an ongoing unwillingness to fully recognize and address situations where the system may have failed. This reluctance underlines a broader pattern of resistance to admitting institutional errors, which ultimately undermines efforts to ensure justice is fairly administered. In other news, there has been a development on joint enterprise. We discussed the upcoming publication of a report on joint enterprise in our video Caught in the Net, Untangling Joint Enterprise. That report, authored by Nisha Waller, entitled The Legal Dragnet, was published on the 11th of September 2024. This can be downloaded for free from the Center for Crime and Justice Studies webpage. The core findings of the report was said to be that joint enterprise laws are vague and wide in scope, causing systemic injustice, including overcriminalization, overpunishment, discriminatory outcomes, and convictions where there is no compelling evidence of intent and a defendant's physical contribution is minimal. In terms of the actions required, the publication page states that given the gravity and long-standing nature of the concerns about the current law, the scope of secondary liability law or joint enterprise needs to be narrowed in favor of a clearer and safer legal framework, preventing wrongful convictions and their grave implications should take priority over the ease of prosecution. Narrowing the scope of the law should encourage better precision from the police and prosecutors from the outset of charging a case, and allow greater confidence that juries are convicting defendants based on their contribution to the crime rather than the prosecution's case theory or narrative. The report was supported by 6 MPs, including Ms. Diane Abbott, led by Liverpool Riverside MP Kim Johnson, who sponsored an early day motion on the 10th of September 2024. Early day motions, or EDMs for short, are motions submitted for debate in the House of Commons for which no day has been fixed. and are used to put on record the views of individual MPs or to draw attention to specific events or campaigns. This specific early day motion on joint enterprise, initiated by Kim Johnson MP, calls on the government to request a law commission review of joint enterprise with a view to narrowing the scope of current legislation and providing a safer framework for prosecution and sentencing. The motion has been so far signed by 20 MPs, including the 6 sponsors. We will keep an eye on the progress of this early day motion and hope that this issue finally gets the attention it desperately needs. Now, before turning to the second part of this new session, please ensure that you click the like button below and consider subscribing to this channel if you haven't already to assist us with our mission of humanizing the criminal justice system. Also ensure that your notification bell is on so that you do not miss our videos or shorts. Now, turning to this month's relevant events. It has been a pleasure to attend International Falsely Accused Day for a second year round. We were pleased to catch up with Brian and Elaine Buckle. We learned with sadness of the refusal of Brian's compensation application by the Ministry of Justice, but we're delighted to see how determined he continues to be in his search for justice, fully supported as always by his wife Elaine. We also met again with Kevin Felsted, who, following up from the winding up of the British False Memory Society, of which he was Director of Communication, he has now founded an independent consultancy which provides help and support to the falsely accused. More details can be found on the website memoryandjustice.co.uk. He has also published his latest book, Memory and Injustice: Wrongful Accusations in the United Kingdom, which is a compendium of his extensive courtroom experience and criminological work acquired whilst working for the BFMS and can be found on Amazon. We also had the opportunity to meet new people. We had the pleasure of meeting William Merritt, a former detective from New Zealand and author of the book Rolf Harris. His services were pivotal to Brian Buckle's journey to justice. We hope you have enjoyed our coverage of such an inspiring event, which we have published in a single video. This is an almost integral representation of that day. We hope it has inspired you to get involved in supporting the falsely accused cause. If you have missed it, you can find it linked in the description below. We are also planning to attend an event organized by the Warren Slaney campaign group on Friday, 27th of September 2024, which is going to take place in Birmingham outside the CCRC headquarters in support of Warren Slaney. Warren Slaney is in his 34th year serving life imprisonment for a double murder which he said he did not commit and for which he has always maintained his innocence. The double murder, dubbed the hot dog murders, as it involved a hot dog tycoon and one of his associates, took place on the 10th of October 1990 in Leicester. At this stage, we know very little about this case. We understand that several innocence projects have looked at Mr. Slaney's case over the years and that an application was submitted to the CCRC in 2005, but that this was subsequently refused. We also understand that the main arguments in support of the CCRC application where, amongst others, the physical appearance of Mr. Slaney, which did not match the description provided by several witnesses, as well as several alibi witnesses who saw Mr. Slaney at a family party at the time when it was said that the double murder took place. We are not sure whether this evidence was adduced and argued at trial. We aim to gather further insight on the day as we meet with the campaign leaders and conduct our own investigation. Once completed, we will provide you with a comprehensive summary and background of the case. Finally, our news session today concludes with an update on the Lucy Letby's case, which we have been following now for almost a year. First, as you may have heard, Lucy Letby has a new legal team, now led by Mark MacDonald from Furnival Chambers. MacDonald frequently advises on appeals against conviction before the Court of Appeal and is involved in several high-profile cases, including the Ben Ginn case, which shares notable similarities with Letby's. We provided a brief outline of Mr. Ginn's case in our video Criminal Evidence Roulette: The Risk of Statistics. However, MacDonald will not be involved in the pending application for leave to appeal against Lucy Letby's latest conviction. Instead, he has been instructed to explore a possible application to the CCRC in light of new evidence brought forward by various experts questioning the evidence used at her trial. Impressively, we understand that MacDonald has taken on this role pro bono. As per the Thirlwell inquiry, as we have previously mentioned, much of this process, at least the initial phase, will occur in private or, as some of you have pointed out, in secrecy. Therefore, we are dependent on transcripts as they become available. What we can confirm is that it began as planned on September the 10th, 2024, that in her opening statement, Lady Justice Thirlwell chose to address the recent concerns raised by eminent specialists as follows. In the months since the Court of Appeal handed down its judgment, there has been a huge outpouring of comment from a variety of quarters on the validity of the convictions. So far as I'm aware, it has come entirely from people who were not at the trial. All of this noise, she adds, has caused enormous additional distress to the parents who have already suffered far too much. She dismisses the legitimate concerns raised by prominent experts about the evidence presented at Lucy Letby's trial as mere noise. Is this a sign of a system in denial? And is history repeating itself? Who can forget Paul Avenel's unsubstantiated claims announced confidently before the Business Innovation and Skills Committee in 2015 that there was no evidence to suggest that any of the post office convictions were unsafe or to suggest any fundamental flaw in the Horizon system? Certainly one individual who took issue at Lady Justice Thirlwell's unsubstantiated remarks was Dr. Michael Hall, who is a retired consultant neonatologist and a visiting professor in neonatal medicine at the School of Health and Science at the University of Southampton. He, according to The Guardian, wrote to the Thirlwell inquiry to set the record straight. He highlighted he sat through most of the trial, and in fact, he provided medical reports for all the babies named on indictments on behalf of the defense. though he was not called upon by the Lucy Letby's team. In a letter published by the British Medical Journal, Dr. Hall raises two key issues. First, he highlights a fundamental misunderstanding regarding the type of air embolism discussed in the Tanswell and Lee paper and its connection to skin discoloration as interpreted both at trial and later by the Court of Appeal. Dr. Hall explains that the Tanswell-Lee paper not only refers to oxygen rather than air entering the baby's circulation, but it also refers to oxygen being pumped at high pressure into the pulmonary system. Different from the scenario alleged at trial, where air was said to have been injected into peripheral vein. Dr. Hall found only one study detailing skin changes linked to the accidental injection of air rather than oxygen into a peripheral vein. Notably, the skin discoloration in this latter study differed from that indicated in the Tanswell-Lee paper or that reported by the trial witnesses. Additionally, the skin discoloration in the study was non-transient and migratory, unlike the description given by trial witnesses. Dr. Hall suggests that had the Court of Appeal sought an independent opinion from a suitably qualified expert, and we add, instead of making judgment outside their expertise, these concerns would have been raised. He also questions the Court of Appeal's statements that A, the two prosecution expert witnesses, Dr. Evans and Dr. Bohane, were suitably qualified to give evidence, and B, that it was for the jury to assess the validity of the evidence they provided. Dr. Hall raises doubts, first, about whether the Court of Appeal had the right expertise to determine if Dr. Evans and Dr. Bohane were appropriately qualified, particularly as he highlights that both had been retired for 15 and 13 years respectively by the time of the events in question. Secondly, he questions how the jury could have assessed the validity of their testimony when they were not provided with peer comparisons presented by the defense. And we agree with his position. The jury in this case was not only tasked with determining whether Lucy Letby committed the offences, but it was also tasked with deciding whether an offence had even occurred in the first place. Not only that, it had to do so on the basis of incomparable, substandard and one-sided medical evidence. Lady Justice Thirlwall also suggested that this noise, as she describes it, is causing unnecessary distress to the parents of the babies. However, I struggle to see how this is unnecessary. First, to my knowledge, everyone who has raised doubts about the evidence in the Letby's trial has acknowledged the ordeal the parents are going through and shown nothing but respect for them. Second, it is in the parents' interest, as we've said before, to uncover the truth rather than avoid raising concerns simply to make things easier. It will be far more painful if these doubts are left unresolved, only to resurface years later, as it has happened, for example, in Mr. Markinson's case or the post office scandal, only to mention recent cases. Only time will tell whether all this noise was justified and justifiable. Also, some interesting points have emerged from the Thirlwall inquiry so far. In his opening note on the 12th of September 2024, Mr. Peter Skelton KC, representing families of children A, B, L, M, N and Q, remarked, and I quote, "Most critically, as soon as they," referring to the pediatric consultants, the likes of Dr. Jaran and Dr. Breary, "suspected Letby had harmed babies deliberately, they should have articulated their suspicions clearly and formally in writing and made sure that they were brought to the attention of the senior managers and the board, and when those managers refused to take immediate and appropriate action, the consultants should have gone to the coroner or spoken to the police." A key example of this failure, you may feel, was the inquest into the death of child A, which took place before Coroner Nicholas Reinberg on the 10th of October 2016. At that inquest, hospital staff, including Dr. Jaram, gave evidence under oath, but for reasons that will require clear justification when they give evidence, no one told the coroner there had been a concerning cluster of deaths at the hospital, that this was being investigated, and most critically, there was concern that a member of staff was involved and was harming babies deliberately. The opening note by Mr. Blackwell KC, representing the Countess of Chester Hospital's senior managers, also made similar remarks. She starts by referring to submissions made to the inquiry that the senior managers lacked professional curiosity. However, she said, there was nothing tangible being alleged beyond Letby's presence for a long period of time. They struggled to know what they might say to justify a criminal investigation. This was the cause of a significant delay in contacting the police, and for this they are truly sorry. She added, "It will be a matter of explanation for this inquiry as to why those who held concerns about criminality," she clarifies later, this being the doctors and the nurses, "did not contact the NMC, the police, or any of the other relevant external bodies." And of particular importance is the following passage extracted from the Thirlwall inquiry transcripts of the hearing of the 13th of September 2024. She said, "Whilst senior managers were made aware that Lucy Letby had been moved to day shifts for 3 months, they had understood from what they were told that this was due to work-related stress, and they were also told that there were no known performance management issues or complaints against her, and that she was considered by nursing colleagues to be a diligent nurse with excellent standards." This picture, however, changed at the end of June 2016 when concerns were raised for the first time to senior managers by Dr. Breary, who, as I have said, was present at the 11th of May meeting, and Dr. Jayaram about Lucy Letby being concerned directly in the death. These triggered numerous meetings, as my lady is aware, throughout the remainder of June and July, attended by senior managers and consultants. However, aside from the link between Letby's shift patterns and the deaths, at that stage nothing specific was articulated by either Dr. Breary or Dr. Jaram or any other consultant to the senior managers to identify what that wrongdoing might be. For example, there was never any suggestion by Dr. Jaram that he had witnessed an event in February 2016 involving Letby that raised suspicion about her behavior towards child K, about which he kept silent. until March 2017. Nor had there been anything raised with senior managers about child F's insulin results back in August of 2015, for which accidental administration had been excluded as a cause, but then about which no further action had been taken. There was nothing raised about any failure in the care the Letby had given to any of the babies to indicate that her conduct had or might have contributed in any way to the deaths of the NNU. These undefined concerns were not shared by nursing staff. Indeed, as my lady is aware, the NNU manager, Powell, was firmly of the view that Letby was a good and competent nurse. In addition, at this stage, it appeared that there was also a doctor who had been on shift at the time of several of the incidents. And as my lady knows, the coroner's authorization form 1 had been issued in relation to all 7 cases in which babies had died. The coroner had therefore been alerted and had the opportunity to investigate, but no concerns or issues had been raised during that procedure. In all of those circumstances, the inquiry will want to ask what evidence was there available at the time upon which senior managers could have based a view that Letby was responsible. Who can forget Dr. Jairam in his interview to ITV News when he told us how the night of the 17th of February 2016, when he walked in on Lucy Letby standing over baby Kay's cot, was etched in his memory and will remain in his nightmare forever. However, as it now has come to light, he chose to disclose this pivotal moment, which was crucial in securing Lucy Letby's latest conviction, only in March 2017, over a year later. As Ms. Blackwell KC rightly pointed out, it is a matter for the inquiry to investigate the reason behind such odd behavior by the consultants, especially since they should have been fully aware of the possibility of criminal activity, as per the Clothier inquiry's key recommendation following the Beverly Allet case, which emphasized that her action should heighten awareness amongst those caring for children about the potential for malevolent intervention in unexplained clinical events. While we are not making any assumptions regarding this unusual and indeed odd behavior, we are eager for the inquiry to shed light on the matter in due course. The inquiry will hopefully provide clarity on the reasons behind these actions and offer insight into whether they had any broader implications. This concludes today's session. As always, the comment section below is open and we welcome your thoughts on any of the topics discussed today. Feel free to continue the conversation in our secure and private networking hub at spokeninjustice.net if you prefer, where joining will automatically make you a member of our community. We look forward to hearing from you. Join us again as we sit and rise in this unique trial.